Okay, everyone, just going to give it another 20 or 30 seconds just for some people to arrive here a little late, and then we'll make a start. Okay, well, let's make a start looking at this issue. First of all, I'd like to thank the Chartered Institute of Civil Engineering Surveyors for this opportunity to give this lunchtime talk. And what I'm going to try to do is demystify a couple of terms that we use in construction and a couple of tools we use in construction in and around the contract formation. One is collateral warranties and other are letters of intent. And we picked these out because people often get confused about them and get concerned about them. And really, what I want to do, as I said, is try to demystify it a little bit for you. Quite a lot of you will know me, but I was a civil engineering surveyor and a fellow of the Chartered Institute of Civil Engineering Surveyors. And then I became involved more and more in the dispute resolution side of things. And now I'm a solicitor practicing in England and Wales and both jurisdictions in Ireland. Come from Quigg Golden, who specialise in construction dispute resolution. For more information, you can look us up. So we're looking, first of all, at collateral warranties. Now, I should say to you that if you have questions, the best thing to do is to type those questions up into the chat box that you should have in your GoToWebinar selection. And I will try to deal with those as I go through and try to deal with them at the end. I've certainly allowed some time at the end to answer some questions. So please do ask away if I haven't explained something properly. So what are collateral warranties and why do we have them? Well, firstly, the term collateral warranties. Collateral we can replace with alongside, and the word warranties we can really replace with contract. So it's a contract running alongside the normal chain of contracts we have in the construction industry. If we take a typical situation here, we have an employer at the top who's entered into a main contract with the main contractor, who's entered into a subcontract with the subcontractor. Let us suppose that the subcontractor is a piling subcontractor that installs the piles for a 10-story high office building. In carrying out that work, let us suppose that the piling company used defective concrete, didn't use the right grade of concrete in the piles. And as a result of that, several years later, the building started to subside. Well, what would happen in that situation is that the employer who has the defective building would sue the main contractor for breach of contract, and the main contractor would in turn sue the subcontractor for breach of their subcontract. And there's no difficulty in doing that, and it happens every day. And in fact, both cases would be joined as one case in the High Court. If it's an arbitration, it can still be joined. If it's adjudication, could still be joined, but it's more likely to be separate. But very common, and there's no difficulty. Where the difficulty comes is what would happen if the main contractor no longer existed. Perhaps, and sadly, it has become insolvent, or perhaps it was a special purpose vehicle, or for whatever reason, it's no longer possible for the employer to sue the main contractor because they don't exist. Well, what can the employer do? Well, there is no link, there is no contract between the employer and the subcontractor, so they can't sue the subcontractor for breach of contract. They can't sue the main contractor for breach of contract because there is no contract, no main contractor. So they can't sue anybody for breach of contract. Now, they might be able to sue the subcontractor for negligence, tort of negligence. But that is not an easy route for the employer to go down. For example, if you sue for negligence, you can't claim for what's called pure economic loss. And I'll give you an example. A building had cladding panels attached to it. A cladding panel fell off and damaged a car. Luckily, nobody was injured. And the employer, the building owner, went to sue the main contractor, but the main contractor was bust. Therefore, had to sue the subcontractor and was able to sue the subcontractor for the damage caused to the car. But the fact that all the other panels were going to have to be taken off and the fixings changed was classed as pure economic loss. So all of that cost of repair that the employer was going to face couldn't be recovered through negligence. Could easily have been recovered if there had been a contract with our subcontractor, but there wasn't. So that is the situation which causes difficulties which collateral warranties are designed to remedy. In this little graphic, the standard contracts are the solid lines, and the potential collateral warranties are the dashed lines. And here we've extended it to the funder. So there's the funder, the employer, the contractor, and the subcontractors. Now, if we put ourselves in the shoes of the funder, perhaps we're a bank and we're lending the money to a developer, which is a special purpose vehicle. In other words, a company that's set up with the sole intent of developing the building. So it has no other assets. Who's going to enter into a contract with the main contractor and then a subcontractor? Well, as the funder, I want to know, well, what happens if this employer becomes insolvent, or it runs out of money, can't afford to complete the building? Therefore, they may want to have a contract, a contractual link directly with the contractor, or one or more of the key subcontractors, and that's the dashed lines. These are collateral warranties. So these are contracts in their own right, which are running alongside the existing typical contractual link. So all collateral warranties is creating a direct contractual relationship between two parties in the construction project, which wouldn't otherwise have a contract in place. A typical situation is a collateral warranty, which is a contract in which a consultant or a subcontractor warrants to a third party, and that third party might be the funder, that it has fulfilled and will fulfill its obligations in its professional appointment or the building contract. And I've said already that the purpose is to give a contractual link so that that third party can sue for breach of that subcontract. So if we take a subcontractor, their primary obligation is their subcontract with the main contractor, but they may also have given a collateral warranty to the employer or to the funder or another party saying, I promise that I will comply with the subcontract I've entered into, and if I don't comply with that subcontract, then you can sue me for breach of that promise. Okay, so that is what a collateral warranty is. So now we know what they are, let's look at some of the common features you might see in a collateral warranty and some of the problems we may come across. Well, first of all, most collateral warranties are a one-way promise, i.e. it's a promise from the subcontractor to a third party that they will comply with the contract. And because it's a one-way promise, it has to be executed as a deed. And if it's not executed as a deed, then to be a valid contract and therefore enforceable, the law says there has to be some consideration. In other words, the subcontractor has to get something in return for his promise that they'll comply with the subcontract. And often you'll see a clause that says something like, in acknowledgement of the payment of £1, receipt of which is hereby acknowledged, we hereby promise. And that gives it some consideration. You don't need that clause to be in there if it's executed as a deed. But then executing as a deed extends the liability from 6 to 12 years. Often we'll see that the collateral warranties with the funder can be trilateral, in which case it will be signed by the employer and the funder and the particular contractor or consultant, the warrantor, the person giving the warranty. The key element in the collateral warranty is the obligation or the promise to comply with the appointment or subcontract that they've entered into. And that's the key feature. There then sometimes are added on to that an obligation to use reasonable skill and care, or to ensure that the work they carry out is fit for the intended purpose. And it's very important here that the provider of the warranty, the warrantor, doesn't inadvertently extend their liability to doing something beyond which their primary obligation is. So what do I mean by that? Let's say we have a subcontractor who is to design and install some steelwork. Well, their design obligation should be, under that subcontract, limited to using reasonable skill and care. They're not promising it will be fit for purpose, just to use reasonable skill and care. Well, what they don't want to do is then provide a warranty to a third party saying, oh, not only will I use reasonable skill and care, but I'll go beyond that and I promise it will be fit for the intended purpose. So it's very important to make sure that your warranty you're asked to sign is not requiring you to give more or do more or have a greater obligation than you do under the base contract which you're being appointed under. Often there'll be a clause confirming that the beneficiary can't instruct the warrantor in relation to the works. A very common clause in a warranty will be a right of the beneficiary to assign it. So let's say you are the developer and you have a collateral warranty from the piling subcontractor. Well, you've developed this office block. If you then sell it to a company who's going to occupy it, you want to be able to assign that warranty. So in other words, the promise is no longer to the developer. He won't have an interest in the property, but the promise is going to go towards the owner of the property. And that's really important. Otherwise, imagine the piles fail, and if the warranty hasn't been assigned, the developer goes to sue the subcontractor, but the subcontractor says, well, you suffered no loss because you don't own this building anymore, so you can't sue me for anything. You've got no loss. And the owner of the building, the new owner, can't sue the subcontractor because there's no collateral warranty in place. So it's important that the beneficiary assigns the warranty over to another party. And quite often the clauses in the contract, in the warranty, will limit the number of times it can be assigned, or some other provision saying at any assignment you have to be given notice of in writing for it to be valid. Sometimes people think, oh, that's great. This warranty doesn't say anything about assignment, so they can't do it. Well, that's not true. You have a right to assign the benefit of a contract as a common law right. So in fact, the assignment clause will limit the way in which it can be assigned. So if you are a subcontractor, you want to see a clause there talking about assignment and saying it can't be done unless you're given written notice in writing, and it won't be valid unless you receive written notice in writing, and it can only be assigned once or twice. Anything like that is restricting the otherwise common law right to assign, which is unlimited. So assignment is good to have a clause in there. Depending on the nature of the collateral warranty, we could sometimes see step-in rights. So let's say we're the funder and we are looking for a collateral warranty from the main contractor. Well, one of the risks the funder might face is that the developer goes bust. And so what they might have is a clause there saying, if the developer goes bust, we can step into the developer's shoes and effectively become the developer in the main contract and continue to pay you, and you have an obligation to complete the building. So it means that a project which is well underway can be finished out even if one of the parties becomes insolvent. In the same way, if we have a very specialist subcontractor in place, then the warranty between the employer and the specialist subcontract may provide that they have the right to step into the shoes of the main contractor in certain circumstances, mainly the insolvency of the main contractor, and take over the subcontract. And that's a good thing for a subcontractor to see, because it will have an entitlement to get paid in that step-in clause. So yes, if the main contractor goes bust, you may have to continue working, this time directly to the employer, but the employer has to pay you for it, which might put you in a much better position than you would have been had the employer not stepped into the shoes. So you can actually maybe start to see here that actually, whereas most subcontractors think a collateral warranty is a dreadful thing that they don't want to have to provide, actually they can have rights that generated from this collateral warranty that put them in quite a good position. So that you shouldn't run away from them just automatically and worry about them. That they are a valuable tool for each side of the equation, the warrantor and the beneficiary. However, if you are giving a warranty, there are a couple of clauses you really want to make sure that are in there. First of all, a no greater liability clause, which will be something saying something like this: notwithstanding anything else stated in this warranty, the warrantor shall have no greater duty to the beneficiary than it would have under its subcontract to the contractor. So in other words, we're saying, yes, we're promising you that we're going to comply with our subcontract, but we're not going to have any greater liability or duty to you than we do under the subcontract to the main contractor. Another way of putting it is you have equivalent rights of defence. And there's different ways that clause can be written, but it's really important that it does have that clause in there. It's very, very valuable. You may also, as the person providing the warranty, negotiate that there will be a liability cap, so that any liability you have under the warranty is limited to some amount, perhaps the amount of your professional indemnity insurance, or 10% of the subcontract sum, or some other figure. Perfectly proper for you to negotiate and try and get that in. A very important clause, as well as the no greater liability, is a net contribution clause. Quite often, the liability for a defect in a building can have multiple people contributing to it. So perhaps the subcontractor didn't do their job well, perhaps the main contractor didn't do their job, and perhaps the designer didn't quite do their job. And it's a combination of all three that has led to this difficulty. And it might be that if the courts, if all three parties were in existence, and the court was dealing with a claim for breach of contract by all three, they might proportion liability a third, a third, a third, or 60%, 20%, 20%, or in what proportion they believe is correct. But of course, if one of the parties isn't there anymore, because they've become insolvent, they can't go a third, a third, a third. They're going to have to split it 50-50 between the two parties which are left. So it's important you ask for a clause to be in there saying that your liability under the warranty is limited to such amount which is fair and reasonable, or just as equitable and proportionate to the amount it's to blame. So in other words, if all three parties were there and the court would have said it a third, then even if two of the parties aren't there and you're the last man standing, your liability will be limited to a third. Okay, so that's important to get in there. Otherwise, you could end up being liable for 100% of the loss, even if your contribution to that was relatively small. You'll also often have a clause in there saying that the provider of the warranty will maintain professional indemnity insurance for a certain period of time, and you should just be aware of that and register that with your company administrator so that that insurance is kept in place. Well, that's all very well and good, so long as the warranties are in place. But often what we see is situations where the subcontractor or the main contractor are refusing or resisting supplying the warranties. Maybe the subcontractor saying, well, I'm not going to supply the warranty until I'm paid. And the main contractor then says, well, if you don't supply the warranty, we're not going to pay you. And we get into this catch-22 situation. So it's really important, if you are an employer, so you're the employer, if you are going to want to have warranties in place, or if the funder requires you to get warranties from the main contractor and the subcontractor, then that obligation to provide the warranties must be incorporated into the main contract. And even where that is done, what I often see is something like main contractor to provide a warranty to the funder on terms to be agreed. Well, that's really unenforceable. So that's no use. It has to be the main contractor shall provide a collateral warranty in the terms set out at Schedule 5 or whatever, or Appendix 5, within 10 days or something like that. It has to be a clear, express, explicit obligation to provide a warranty, who it's to be provided to, when it's to be provided, and the terms. And that's essential. And equally, the subcontractor must do that as well. The subcontractor must have the subcontract must have an obligation on the subcontractor to provide a warranty, who's it to be provided to, when's it to be provided, and what the terms are. There is no point going to a subcontractor halfway through the project and saying, oh, by the way, will you provide a collateral warranty? Because the subcontractor can quite lawfully and rightfully turn around and say, no, I won't. Hard luck. I don't have an obligation to provide it, so I'm not going to do it. And equally, the main contractor can turn around to an employer and say, I'm not providing you with a warranty because that wasn't required. So it's essential that the obligation to provide the warranty is built into the main contract and the subcontract. So long as you've done that, and if a subcontractor or someone else refuses to provide it, the court can require them to do it. And that's an order for specific performance, and they're basically required to provide the warranty. So, but there's no point going to the court and saying, well, my subcontractor won't provide a warranty, and the judge says, well, where is it required to provide the warranty in the subcontract? And if it doesn't exist, the court obviously won't entertain your claim. So essentially build it in there. It's just a typical clause that you might see in relation to the requirement to provide a warranty. Immediately upon the execution, contractor shall provide and execute a warranty in the form of the specimen that is set out, so the terms are set out, and who is to be provided to. Okay, it's not difficult to put that in, but do not enter into contracts where you're going to want warranties without that obligation. So a few practical points to finish up with collateral warranties. Are the parties obliged to sign or provide it? Well, they're only required to provide it if their contract says they're going to have to provide it. So make sure it is set out therein and set out in terms, not just in terms to be agreed. Who are they to be issued to? Again, it depends what the contract says. It has to be set out in there. Are the obligations the same? Well, they should be, and they certainly should not be enhanced. So it's very important that you have a no greater liability clause written into the warranty. Can they be assigned? Yes, they can be assigned as many times as they like, unless there's some restriction on the assignment, say, such as how many times it can be assigned, with or without consent. And then lastly, if you're providing a warranty, make sure there is a net contribution clause in there, so that if a problem arises and you're only partly to blame, you don't end up being fully liable for the loss. So that's what I wanted to say about collateral warranties. Now I'm just going to have a look here to see if there's any questions in the chat window at the minute, and I don't see any comments or questions in the chat. So either that's because I've been so clear, I haven't left you with any questions, which I doubt, or perhaps you can't find the chat window. But anyway, I'll move on to the second part of today's lunch talk, which is letters of intent, and then I'll check back at the end to see whether or not we have any questions. Okay. So letters of intent. Again, something that's often used in the construction industry, but sometimes without any proper or clear understanding of what they are. And before we look at letters of intent, I think it's helpful just to refresh our memory in relation to contract formation. And in the construction industry, or don't know what happened there, folks. Let me go back. In the construction industry, or anything actually, any contract you enter into, whether it's buying a can of baked beans at Tesco's or buying a 20-story hotel building, we require offer, acceptance, consideration, and an intention to create legal relations. And offer and acceptance is often comes about by the signing of a contract, because there's clearly an agreement there. But if there isn't a signed contract, we look for what was agreed, which means we're looking for offer and acceptance. An offer being a clear and unambiguous statement of the terms on which you are prepared to be bound by, and an acceptance being an unequivocal expression of agreement to all of the terms of the offer which have been put forward. We don't really need to worry about consideration and an intention to create legal relations, because very few contractors, well, consideration, first of all, very few contractors offer to build things for nothing, and equally very few employers want to pay a contractor lots of money for no work. There's always an obligation to do work in return for payment in nearly every contract. The only construction contract I can think of that lacked consideration is a project in my home jurisdiction of Northern Ireland, where a builder carried out some work at a convent for free. The nuns said the work was defective and sued the contractor. The contractor said there was no contract because he did it for free, and therefore there was no consideration, to which the nuns argued that they prayed for the contractor daily, and that was the consideration. And the poor judge had to decide whether or not a nun's prayers were valuable consideration or not. But generally speaking, in construction, it's not an issue. And equally, an intention to create legal relations. Really, did we mean to be bound by this promise? Well, there's a presumption that if the promise is made by two business entities or two commercial entities, then there is an intention to be bound, whereas perhaps between family members there's not. So a promise between myself and my partner that if she did the ironing, I would do the dishes, would not be enforceable in the courts, because the court would say you didn't intend to create a legal binding contract that could be sued whenever you made that agreement. But don't tell your partner that until after they've fulfilled their part of it, and then you can say, I don't have to do mine now, and you can't sue me. So that's how contracts come into being. There's a couple of slides there. I think you guys are going to be able to get these slides afterwards, so you can look at them at your leisure. But the offer is an expression of willingness to contract on certain terms, made with the intention that it will become binding as soon as it is accepted. So it's a formal offer, and an acceptance of that is an unequivocal expression of assent to all the terms of the offer, which is communicated to the offerer. And we don't need to worry again about consideration or an intention to create legal relations. So that's what a contract is. So where on earth does a letter of intent fit into this offer and acceptance model that I've said exists? Well, the truth of the matter is it's hard to fit it into that model, and sometimes it doesn't fit very cleanly into it, and you'll see what a couple of judges have said. It's often a letter or a device where one party indicates to the other that it is likely to enter into a contract, but it actually can go beyond that, and it can be a contract to do certain works, and sometimes it can actually be a contract to do all of the works, depending on how it's actually drafted. And if we look at Judge Seymour here in Tesco's, it's part of the folklore. I like that it's folklore of the construction industry that there exists a mythical beast, the letter of intent, the legal effect of which, if it is acted upon, is that it entitles the contractor to payment for what he does, but does not expose him to any risk because it imposes no contractual obligation on him, i.e. the contractor can decide to do some work authorised under this letter of intent, or decide not to do so. In fact, the legal effect of a letter of intent depends upon the true construction of the communication between the parties. In other words, what a letter of intent actually means depends on what you say and how you act. So the judge here is talking about this mythical beast, part of the folklore, and saying, look, it could mean lots of different things depending on what you actually say. And this was maybe set out in three different categories in Diamond Build and Chatham Homes. And the judge there said typically, not always, but typically a letter of intent will work in one of three different ways. The first is that it's a non-binding statement of the intention, or a letter of comfort. Secondly, it could be an interim contract with its own terms and conditions. Thirdly, it could be a final contract. And lastly, I think I would add a fourth category, which is it can actually be meaningless garbage. So we have to be a little bit careful about how we draft these. Well, let's take the first, a non-binding statement of intention. Well, the key here is it's non-binding. So in the eyes of the law, it is absolutely worthless. It is nothing. It is a nothing. So why on earth might you want to propose one or draft one? Well, it might be that you want it to show others, like a funder, and it's demonstrating a serious intent on behalf of the parties to enter into a contract. It might be that the main contractor wants a subcontractor to put some serious time and effort into tendering for a project, or giving the main contractor a price, and the subcontractor saying, well, why would I do it? Have you got a main contract? Are you in contract to do this? And perhaps the main contractor might want a letter of comfort from the employer, which says we fully intend to enter into a contract. So it is really, in the eyes of the law, it's meaningless. In the eyes of commercial gentlemen and gentle ladies, it could have some meaning. It shows that there is an intention here, and therefore might assist the funder commit their resources in looking at whether or not they'll fund the project or enter into a loan. The second category is the most common category, and it's an interim contract on its own terms, which governs the relationship between the parties and can be used to do some work. The parties, however, have to be very careful with these types of letter of intent, because all too often, once they're entered into, attention and focus will the intention and focus of agreeing the main contract will start to disappear. So we've got a situation where there's a main contractor and an employer. They're mad keen to get started. The contractor's won the tender. The employer wants to get their building underway. There is some negotiation going on in relation to the main contract, and everybody's efforts are to get those terms agreed. Because until it's agreed, the contractor isn't starting work on site. Well, what we could do in this situation is enter into a letter of intent that says, we intend to enter into a main contract with you. Until such times as we do, could you please come to site and start doing the demolition and excavation, bulk excavation. And if you do it, we will pay you on a quantum merit basis, i.e. we'll pay you for your time and materials up to a value of £150,000. Whenever we enter into a main contract, then that work will be governed by, valued and paid in accordance with the main contract. So now we're in a situation as a main contractor saying, well, that's great, I can go and start working. If we enter into a main contract, I'm going to get paid under that main contract for this work. And if we don't enter into a main contract, it doesn't matter, because I've got a promise here, an enforceable promise by the employer to pay me for doing the work I've done on site. So that then allows the works to start. Okay, the employer's delighted because the building's underway. The main contractor's pleased because he's got a spade in the ground. And the danger of doing it is, of course, that the pressure on the negotiators and the lawyers to agree to main contractor or through main contract terms has suddenly been removed, and people lose focus. So that is a downside, and you'll see later on another potential danger in relation to it. So this is the most common sort of situation. It's an interim contract, or it's a contract saying if we don't enter into a contract, then we will pay you for certain works that you've actually been carried out. However, the courts have given a couple of warnings in relation to this. Sorry, there's an in-between slide, and that's just in relation to a final contract. So in fact, even though the main final contract is being negotiated, because of the way the parties have worded the letter of intent, it becomes the final contract. Okay, that does happen through poor drafting. So should you use the letters of intent? Well, here's a word of warning from this case of Cunningham and Collett and Farmer. So the letters of intent are used too often in the industry as a way of avoiding, or at least putting off, potentially difficult questions as to the final makeup of the contract documents and the terms. There's no doubt that sometimes they're issued in the hope that once work is underway, potentially difficult contract issues will somehow resolve themselves. And they're plainly not appropriate in such situations. So if we take that situation of the main contract and the employer, they're trying to negotiate the main contract terms, but it's dragging on. Well, let's get work started on site. I think it's important to stop and say, well, why are these negotiations dragging on? Why haven't we agreed this? And if the case is you haven't agreed it because both parties are loggerheads and they won't back down, well, why do you think that's going to change? And you shouldn't be embarking on a project where the two parties are at loggerheads and will not agree a term of the contract. So in that situation, entering then into a letter of intent, knowing that there's this irreconcilable tension between the parties' negotiation positions as to the terms of the contract is not the sensible thing to do. And we do see that happening quite a lot. So where would you use a letter of intent? Well, there could well be that there are good reasons to start working in advance of the finalisation of the contract. Let's say, for example, we are still negotiating the price for the finishes. Well, let's get the piling started, guys. Let's get the founds in while we negotiate the finishes. The worst thing that could happen here is that we don't agree the price for the finishes, in which case I can just appoint another contractor to do it if we don't reach agreement. It's quite simple. We don't need to get you to lay the carpet if we can't agree the price for the carpet. It could be that there are materials with very long lead times. And so we may want to allow the main contractor to place orders with, a steel mill for certain section sizes, or with an escalator company for escalators, which are notoriously long lead times. And by entering into a letter of intent, allows the main contractor to go ahead and place those advance orders, knowing that if the contract negotiations break down, he's still going to get paid for any obligation with those advance orders. But again, from Cunningham, the warning, there's a clear risk that agreement will not be possible on all the matters necessary to give rise to a full and binding building contract. And if there is no such agreement, no principal contract will ever be entered into. And that's an inevitable risk of a letter of intent, which creates respective rights and obligations, no matter how carefully it's drafted. So I think with this idea of using letters of intent to allow works to progress while you're negotiating the terms of the contract, take a breath before you draft that letter of intent and ask yourself, well, why is it? What is causing us not to be able to conclude the main contract? Surely it's easier just to finish our negotiation and sign the main contract. And if the reason is because we've got irreconcilable differences, well, then you shouldn't be entering into a letter of intent in relation to it. But whenever you're drafting a letter of intent, some of the elements that should go into it, you clearly want to identify who the parties are, fair enough. Explain the purpose and nature of the agreement, and that's like a recital. So it sets out, whereas we intend to enter into a contract, whereas those negotiations are ongoing, we would like to get some work started on site. And then it has to set out the key terms. What is the scope of the work? And very important there is having a cap on the value. But what is it? Is it just the groundworks? Is it ordering advanced materials? If so, what materials? It's also important to set out requirements in relation to the quality of the works. There was a famous situation of Cleveland Bridge and British Steel, where Cleveland Bridge were a structural steel fabricator, an erector. British Steel were to supply the sections, but very importantly, supply certain nodes. They were in this situation where they couldn't agree the main contract, so they entered into a letter of intent. British Steel then delivered these nodes, but did not deliver them in the order they should have been delivered, and caused a horrendous delay to Cleveland Bridge because they couldn't direct the steel structure out of sequence. There's no point having the last node you need at the start and the node you need at the start at the end of the delivery cycle. Well, they never did enter into a contract, and they fell out. And British Steel said, well, you have to pay me because the letter of intent says I'll be paid on a quantum merit for the nodes I provide. And I provide you with all the nodes you need, and therefore you have to pay me. And the judge agreed and said, yes, you have to pay this. And Cleveland Bridge says, well, we've got a big counterclaim because the way you delivered them, the program and the sequence you delivered them, have caused us a massive delay and costs. And the judge said, well, they may well have done, but there is no obligation in this letter of intent as to program or delivery sequence, and therefore the counterclaim failed. So although it's tempting to write a short letter of intent without too much by way of specifying the quality, program, and so on, you have to do that. You still have to make reference to the earthwork specification, the steelwork specification, some requirement is in relation to program, or else the main contractor could take as long as they possibly want. Imagine that situation where you enter into a letter of intent to do the demolition and earthworks, and the contractor takes a year to do 2 weeks of work. Well, you can't then say there's a 50-week delay because there was no requirement to do it within the 2 weeks. So that's often the scope, as in quality and schedule program is omitted. All too often it just says commence work on site up to a value of 150,000, and that's not sufficient. Should also have payment terms set out because it is a construction contract within the meaning of the Construction Contracts Act, or in the Northern Construction Contracts Order of the Housing Grants Construction Regeneration Act. It should also then go on to set out the steps needed to conclude the overall agreement. It has to include some termination provisions to bring it to an end if negotiations aren't going well, have a clause governing the law and jurisdiction, and dispute resolution, because if your preferred dispute resolution process is going to be conciliation or arbitration, that has to be built into your letter of intent. And look, guys, I really think it is one of those documents that you need to take some specialist legal advice in relation to drafting. Most letters of intent, I think I see, and of course I only see the letters of intent that cause difficulties, but quite a lot are drafted by a project manager or a surveyor with perhaps not a lot of legal input, and perhaps they don't fully appreciate what they're actually doing, and that can lead to some difficulties. So that then brings me to the end of the second element that I wanted to talk about to you in relation to letters of intent. In summary, in relation to letters of intent, don't be put off by them. They are a valuable tool in the construction industry. But before you draft a letter of intent and before you issue it or decide to do so, do stop and ask, well, why do we have to issue this? Why can't we just enter into the main contract today? And if it's because you do have these seemingly irreconcilable and pretty fundamental differences as to the terms, well, why do you think that's going to alter once you issue the letter of intent? As soon as you issue that letter of intent, the commercial pressure is off in doing that negotiation. So often it's better to keep it there. I am aware of a very large shopping centre located not too far from where I'm sitting at the minute, and that the final account was signed on that shopping centre about 6 months before the main contract was agreed, because it was built entirely under letters of intent. Didn't end up in a massive dispute, all went very well, but maybe that's more by luck than by any design or judgment. So still don't see any questions in the chat. Perhaps somebody could put something in the chat just so I know it's working. Oh, okay. Okay. So people. Right. Okay. So I found some here because they've been typed up under the question section rather than the chat section, which I was looking at. So I can take a few minutes to try and answer some of these. Bear with me till I try and get them up on the screen. Okay. Where do we start? In consideration of what is said, all collateral warranties are tripartite, not just those involving. No, collateral warranties can be just with two parties in them, just between the subcontractor and the employer. They only really become tripartite if there are step-in rights that go with it. The no greater liability could introduce a. This is quite frustrating, folks. Okay, I've got it now. No greater liability clause would introduce a cap, assuming the cap is in the subcontract. Is that correct? Yes, it is. So if your subcontract says we can't be liable for more than 100,000, and there's a no greater liability clause in your collateral warranty, it would be limited to that same figure. Collateral warranty step-in provision. Don't do it without suitably worded break provision. Can it be instantaneous step-in? Yep. I think if you want to step-in rights in the collateral warranty, you do want to think through how will this operate in practicality. It's a good thing to have, but you do need to read that clause correctly. Somebody's asked, are third-party rights act as an alternative to collateral warranties? Yes, exactly right. Law Commission decided that actually we should be able to have enforceable obligations in a contract between A and B that maybe C could enforce, and therefore brought the third-party rights in. And that should have done away with the need for all these collateral warranties. However, the effectiveness of building in third-party rights in a contract hasn't really been tested by the courts. So what you find is you have conservative lawyers who are advising their client saying, well, let's just use the tried and tested approach as opposed to this third-party rights, which hasn't been fully tested, and therefore go down that conservative approach. Another view is that there's an awful lot of money made by people drafting and agreeing and negotiating the wording of collateral warranties. So why would lawyers want to do away with them? But maybe that's just unfair. Somebody's asked if the consideration of £1 is not paid, does it become unenforceable? But normally that clause that gives consideration, it says an acknowledgement of the payment of £1, receipt of which is hereby acknowledged. So even if it hasn't been paid, it's deemed to have been paid by that clause. Okay, the point about pure economic loss in tort. Look, it's a difficult one to go down in the time I have available. But whereas a breach of contract would cover the cost of repairing the thing itself, which is broken, in tort of negligence, you can't claim for the cost of repair of the thing itself. So, for example, if you had in a house, if your radiator, it's not quite the same, but you'll get the point hopefully. If your radiator sprang a leak, which damaged the ceiling, your insurance company will pay to replace the ceiling, but not the radiator, because it was the radiator itself which caused the loss that is covered. That I can't really go into that in any more detail in the time available. But if the person who asked that wants to email me, I will certainly pick it up with you. Okay, somebody thanked me, which is very kind of him. I've experienced clauses where money can be withheld until the collateral warranty is at acceptable. Yes. So very common, where I said the subcontract has to say that the subcontractor has to provide a collateral warranty, then it's very common to say no payment is due until the warranty is provided. and that is acceptable or enforceable, depending on what way you want to put it. Okay. I can't remember if the prayer was going to be good consideration or not. Actually, I must look it up. I cannot remember for the life of me. I don't think it was, but I need to check. In the letter of intent, should a schedule of payments be included? Yes, I do think it should. And if you don't include the schedule of payments, then the letter of intent, as I say, would be a construction contract. So you would drop back to the Housing Grants Construction Regeneration Act. It doesn't have due dates, and therefore the scheme would apply, or in the south of Ireland, the schedule. Okay. Right. Somebody has helpfully pointed out to me that in order to use chat, they had to do something. So we'll maybe clarify that for next time we're talking to people. A letter of reliance. Well, a letter of reliance, I think probably a letter of reliance, like a letter of intent, it doesn't always mean the same thing. It depends on what it actually says. And I think this is part of the problem of letters of intent. People read what a letter of intent is in a textbook when they're at university doing their QS degree or their engineering degree. But actually, there is no such thing as a letter of intent. It could fall into any one of those 4 categories, the last of which is meaningless garbage. So you need to read it itself. Okay, someone else is asking me about the nuns, so I'm going to have to look that one up. Should letters of intent include insurance provisions? Yes, I think they should. They should include that. If you require insurance, they should have it. Explain the Turner and Townsend case about misuse of several letters. Well, I will, but again, the guy who asked me that, drop me an email and I'll come back to you, but that would take a little while. Okay. I think that is all we have time to cover in terms of the questions. I know I haven't got to everybody, but my time is up and I have to keep to the time. So what I always say to people is, look, please do, folks, feel free to drop me an email. My contact details are on that last slide, or you can Google me. Thankfully, with the names Quigg, there's not that many of us. And I'd be more than happy to answer any of your questions on email that I haven't got to. I hope you enjoyed, or if not enjoyed, got something from it. And thank you again to the Chartered Institute for the opportunity. Have a great afternoon, folks. And I hope you'll all join with me cheering on Ireland and England and Wales, why not, on Saturday and Sunday. All right, bye.